Good morning. I am back. We have a lot to discuss. A lot. Okay? We got a lot to discuss. I am back. We have a lot to discuss. Let me know in the comments how are you, how you feeling, how is it going. We got a lot to talk about. A lot to talk about. We have a lot to talk about. Let me start with one thing and one thing only. Where is going? We have a lot to talk about. How are you? How you feeling? Let me know in the comment. We really have a lot to talk about. I want to start with greetings. Let me put the comment up. Oh, hold on. Greetings, Kabe Kamara. How are you? Good morning. Good morning, Timothy, Paige, Joseph. Good morning. How are you? Annie, good morning. How are you? We have a lot to talk about, okay? I don't know where to start. Good morning, Christiana. Good morning, Abigail. How are you? Yes, we have a lot to talk about. I want to start with parole, okay? Parole for spouses of U.S. citizens. We're going to start with that, and then we're going to talk about D3 waiver. Then we're going to talk about politics, okay? What's really going on, and what exactly can somebody in without legal status can do under those circumstances, okay? We have to go slowly because, but if you have a question, meanwhile, just put it in the comment when I pull those pages up, okay? When I pull those pages up, just put it in the comment. If you have something to say, put it in the comment. Okay. I want to start with this one. Okay. Yeah, I want to see something. Not this one. If you have a question, just put it in the comment. Something I want to see here. I want to talk about the document, right? The document that is needed. I saw it somewhere. saw it somewhere. Okay, we have questions. Good morning. Good morning, my dear. Good morning. How are you? Sila, is genital mutilation of women crime to be an asylum case? Could you talk a little bit about it? Good morning, Sila. Yeah, people do apply for asylum based on that. If they suffer it, or the fear they're gonna suffer, they're gonna go through it. It's considered persecution here. A lot of people that I know, I personally know a client from Mali that we apply for asylum based on it, and she was basically a victim of it, and because she had proof and she went to the hospitals here, and she was able to make her case. So if you're asking, is it a crime? I wouldn't consider that a crime if it's not a crime in the country where they live. But as far as making a case for asylum, of course, it is considered persecution. Okay? And somebody can make a case based on it. So I hope I answer your question. Let's talk about this. Okay. I'm going to share my screen so we can get started. Let me share my screen so we can get started. Okay. Process to promote the unity and stability of families. When is it going to start? It's going to start on August 19. August 19, that's when a person can apply. Okay. Eligibility: be present in the United States without admission or parole, have been continuously present in the United States for at least 10 years as of June 17, 2024, and have a legally valid marriage to a U.S. citizen as of June 17, 2024. Case by case basis. Those are the basis requirements. Okay, if you meet this requirement, that's when we're going to file for. But when exactly are we going to be filing? On August 19. And they have to publish something in the Federal Register notice. Once they publish it, I'll come back again, start talking about it. But what are the documents? Okay, the documents basically you have to show proof of continuous physical presence in the United States for the past 10 years with a cutoff date of June 17, 2024. What exactly can you show? You can show valid proof of ID if you have it. You can show notices from USCIS, because some people apply for asylum before, or they're in court. If the notice to appear is dated from 10 years ago, that's proof enough. Taxes, if you've been filing taxes, whether you file it with a TIN number or a social security number, those are proof enough. Certificate of marriage, if it's dated back 10 years prior to this date of June 17, 2024, yes, that's proof enough of physical presence, continuous physical presence. Okay. What else? Sorry. Yeah, documentation to establish that the non-citizen has been continuously present in the United States for at least 10 years as of June 17, 2024, the 10 years physical presence. Evidence of legal valid marriage to a U.S. citizen, the certificate of marriage, evidence of additional federal discretion. Okay, basically for them to see if the marriage in question is a good fit marriage. And then they go with questions here. You can, if you have criminal records, it's not going to work unless the crime in question is waivable, right? But otherwise, merit favorable discretion. Okay. Let me see. Let me stop sharing here. Stop sharing. Okay. Good morning. Good morning. How are you? We are talking about the news, the latest immigration news. August 19, USCIS will be accepting parole in place for spouses of U.S. citizens. They will be accepting that. So that's what we're talking about here. If anybody has a question, they can ask, put it in the comment. We wanted to go over the document. Let me see if I can find it again. I had it. But if you have a question, just put it in the comment, and then after that we are going to be talking about this D3 waiver. Okay, remember that executive order from Biden suggests that DACA applicants with degrees can have a process in which it's allowed them to go get their work visa outside, right? By getting the D3 visa waiver approved. Okay, we're going to talk about it as well. Yeah. So if you have a question, just put it in the comment. Okay, so we want to talk about what document. Let me open it and see what document to use. Oh, my case got finally remanded from BIA to the IJ so I can file for cancellation of removal. Good news. Good news. Congratulations. That was, we were kind of scared, right? So we were scared about this Supreme Court decision, but this is a good news. Congratulations. I hope your cancellation of removal works. Congratulations. That's great news. Yeah, we got great news. Yeah, we got great news. That's really great news. Okay, so let me show you the document. Let me share my screen again and show you what type of document, okay, is needed to prove this parole in place. Yeah, you're welcome. You're welcome. Let me show you share screen. Enter screen. Okay. So, first of all, eligibility. We're going to talk about it because people keep asking questions. Am I eligible to be considered for a discretionary grant of parole on case-by-case basis? Under this process, you must be present in the U.S. without admission or parole. If you came with visa, you're out. If you were parole, you're out. You see, be present without admission or parole. Have been continuously present in the United States for at least 10 years as of June 17, 2024. have a legally valid marriage to a U.S. citizen as of June 17, 2024, not have any disqualifying crime history, or otherwise constitute a threat to national security or public safety, and otherwise merit a favorable exercise of discretion. Not have any disqualifying crime history. You see, when they say disqualifying, because some other crimes you can waive it, right? As long as it's, you have to, the way you have to look at it is the way you look at adjustment of status. Anything that is waivable for adjustment of status, you can be waived, right? Provided that, you know, they exercise favorable discretion in granting the waiver as well. But if it's not waivable under adjustment of status, then it's just not going to be waived under this parole. That's just how you can look at it, okay? So you cannot apply for this process yet. Again, available on August 19. What they're saying is they will publish a federal register notice that will further explain eligibility and application process, including the form to use and the associated filing fees. Right now, nobody can apply. Just wait. Okay? So, what can you do now? That's the reason we want to, that's actually why we want to talk about. That's why we have this live session. What can you do between now and August 19? Okay, or August 18? What can you do between now and August 18? Okay? You can prepare by gathering evidence, such as evidence of legal valid marriage to a U.S. citizen, those evidence such as a marriage certificate, okay, documentation of proof of identity, including expired document, may include valid state or country driver license or identification, birth certificate with photo identification, a valid passport, or any government issued document bearing the requested name, date, birth, and photo. Evidence of your spouse U.S. citizenship, such as passport, birth certificate, or certificate of naturalization. Documentation to establish your continued presence in the United States for at least 10 years. Okay? What type of document? Rent receipt or utility bills. You see the documents? Those are the documents you have to have. Prepare. School records from your children, or letters, report cards, hospital or medical record, attestation to your residence by religious entities, basically affidavit, right? Official record from religious entity confirming participation in religious ceremony. You can get it from your church, affidavit. Money order receipt or money sent into or out of the United States. If you send money to your family back home, they're going to look at the date that shows proof enough of your continuous physical presence for the past 10 years. Birth certificate of children born in the United States, dated bank transaction, automobile license, receipt, title, registration, deed, mortgage, rental agreement, insurance policy, or tax return or tax receipt. We have been talking about it, but now they have a really long list. You can look among other things, if you have those things or some of those things, to establish continuous presence. Okay? For non-citizen children, remember that if you are the person who's not in legal status, and the person who's undocumented, that person, if they have children born outside of the United States, they can benefit from it too, right? Evidence of child relationship to the parent, to the non-citizen parent, such as birth certificate or adoption decree. Evidence of the non-citizen parent legal valid marriage to a U.S. citizen. Evidence of the child presence in the United States as of June 17, 2024. Okay? Be aware of scam. Like right now, they're not taking, and then they're talking about where you can get report scam. Okay, so that's it. This is the list. Okay, you see the list? You got the list. You got the list. You got the list. That's exactly what we are going to be doing. Then I'm going to talk about the D3 later on. Let me take questions first. What is the expectation? Well, now that the are you talking about your case, right? So now that they send your case, remanded your case back to immigration court so that you can apply for cancellation of removal, just know that cancellation of removal has a very higher standard in terms of proving extreme and unusual hardship. The other element is pretty simple, right? Physical presence for 10 years, no criminal record, good moral character. I'm pretty sure you're a person of good moral character. That's when they look at your criminal record or affidavit of support. But when it comes to proving extreme and unusual hardship, that's where people get stuck, because if you don't have anything extreme and unusual, it's not going to work. An example could be this. I can give you an example, right? Let's say somebody who's applying for cancellation of removal and have a child who's sick. For example, the child he's an autism, for example. That's unusual. Not everybody has this type of sickness, right? Let's say the child's going under treatment of cancer, chemotherapy. Some people have sickle cell diseases. Those are just really unusual type of disease, and it's creating extreme hardship to the parent. That's really extreme, establishing extreme and unusual. Pretty rare to have those cases. But if you have just economic reasons and education reasons, well, in totality, it really has to surpass extreme. It has to be extreme and unusual. Sometimes those people who have arguments just like, oh, schools, oh, the kids they have to go there, back to school, school are not as good as here. That argument's a little weak, depending on what other argument they're gonna add on top of it, okay? What about withholding of removal proceeding, asylum pending, I-130 married to a U.S. citizen? Well, of course, if the person came without inspection, the first thing is the person came without inspection, like with no visa. If the person came with no visa, of course they're gonna get granted parole. Then go back to USCIS, to courts to terminate removal in order to adjust status, right? Remember, in order to adjust status, USCIS still has to have jurisdiction. We're talking about getting parole first. Parole is only for giving unlawful entry. If the person came with a visa, then this program doesn't apply to them, okay? How long does it take for military PLP to be approved? Noble ET. To be honest, I don't know. I really don't know, but I heard it doesn't take too long. Yeah, to be honest, I don't know, because I haven't done that yet, so I really don't know. Good morning. I live in Key West, Florida. It is possible for you to file asylum case for my wife because she got here from Mexico border. Mexico border. The first question is, Joseph, did your wife pass the credible fear test? Credible interview fear test. Like, did your wife got parole to the US? Or, you know, like you get the paperwork at the port of entry? That's the first question. And again, if you're filing for asylum, you're gonna file it with the court. But the thing is, yes, I can do it, but if I'm outside of your state, when it comes time to hearing, you're gonna have to fly me there, okay? It's best to get a lawyer just right there, so you don't have to deal with that unless the hearing is by phone. Let me just send you a consultation link, okay, in case you have additional questions, because this is asylum. I can't just like brush like do it like that. So Joseph, this is the consultation link. Please schedule it, because this is asylum case. I don't like to talk about it just like this. But the simple answer is yes, I can do it. The question remains, we can make the hearing online so that you don't pay additional fees for travel, because you are in Florida and I'm here, okay? But if we cannot make it the hearing online or via WebEx, then you're gonna have to pay for me to get there. So yeah, now it's up to you now, right? But this is the consultation link if you have related questions about asylum. Okay. Hello, I'm married, a U.S. citizen. Can I just status with parole under the receive at the border from ICE, but they didn't give me, and I'm not in removal. 212D5A. When did you get to the U.S.? Because if this parole doesn't work, you can go with the new parole. So to that question, I'm going to ask you one more question, Noble ET. You're going to have to look at your notice to appear. If it says arriving alien, then yes, you can adjust status because you're an arriving alien. But if it says you have not been paroled, you have not been admitted, then the answer will be no, right? So yeah, just look at the notice to appear, because the 212D5A, it's really confusing the way it's interpreted. The way I go with that, I just look at the notice to appear to make a decision. Okay. Anybody else has a question? You don't have any notice to appear. Yeah, that one I'm gonna have to research that, because I know there's another parole that you can, it's not gonna allow you to adjust status. And when did you get here? And when did you get here? Because if you got here, let's say 10 years ago, then of course you can go with this new parole, right? If that one doesn't work, yeah. So I think this parole you can, because this one is for humanitarian reason. I think you're talking about the conditional parole. I got here. Oh, you got the parole for humanitarian reason. Under 212D5A, that's humanitarian reason. Of course, yes, you can adjust status if you got married to a U.S. citizen. Yeah, this parole is for humanitarian reason. I believe you can adjust status, okay? If you got married to a U.S. citizen, yes. I mean, you have to file I-130 and you know, and the green card, really. So in order to be able to adjust status, yeah, I believe so, yes, because that one is for humanitarian reason. I think, did you get your parole based on like being from Haiti or Nicaragua, Latin America, or Cuba or something along those lines? Yeah, if you got that, then yes, you can. You're welcome. So, okay, what else? Okay, so the last subject I wanted, not the last, I wanted to talk about is the D3 waiver. Okay, let me talk about it a little bit. Let me find it so I can talk about it. Okay, let me share my screen again. Let me share my screen for a moment. Ooh. Okay, I want to talk about this one. 212 D3 waiver. Okay, what is this waiver for? This is for, remember when Biden came with this executive order for parole in place for spouses of U.S. citizens. Along with, in that executive order, they talked about how they're gonna help DACA recipients with degrees to get a way to get their visa from abroad. Usually, the way it works for DACA applicants, because they have travel documents, they can go outside to get a visa, right? If it doesn't work, at least they have parole, they can come back. I mean, advanced parole, not travel document. But the thing is, how can you waive unlawful presence? So if you did not accrue unlawful presence because you were a minor when you got here, you can still apply for this waiver. Okay, or you accrue unlawful presence, basically you can apply for this waiver just to be safe. And now what they're saying, there's some factors that the consular officer will take into consideration whether to recommend a non-immigrant visa waiver for certain inadmissibility grounds. The factors include the recency and seriousness of the activity and the condition causing the applicant ineligibility, the positive or negative effect, okay, and whether the planned travel on U.S. public interest, whether it was a single isolated incident or pattern. Those are just the factors that it has to be considered prior to giving this waiver. Okay, and then they go on and explain. So this 1D3 waiver, 112 D3 waiver, okay, that's really for DACA recipient and people who have degrees but they cannot adjust status if they get sponsored by employer because of unlawful presence. They're pretty much stuck. But DACA recipient, they have a way to get unstuck because most of the time they did not accrue unlawful presence because they were minors. Okay, and this D3 is going to help them once they get outside to waive some of those unlawful presence for them and be able to get a work visa from outside. But the thing is, if you are a DACA recipient, always advisable to get advanced parole prior to traveling outside because you never know how it's gonna go over there. Okay, let me stop here. No, I was released on ICE detention at the border with that parole due to medical reason. Yes, those are humanitarian reasons. In other words, you were parole in the U.S. So of course you can, I believe you can adjust status once you get married to a U.S. citizen, because it's for humanitarian reasons, I believe. What else? Good morning, Patel. How are you? Yeah. So, in conclusion, what's going on in politics, we already know. With Biden dropped out of the race, we don't know who's going to be the nominee for the Democratic Party. And then we have Donald Trump on the Republican side. And we already know Donald Trump policies when it comes to immigration. We've lived through it. So if you have anything that need to be done in terms of motion to reopen, specifically motion to reopen, you want to reopen your case, you want to dismiss your removal, this is the time. There's no better time to do it than now. First of all, because the Dolly memo is still going on, still valid, you can get prosecutorial discretion. Second of all, some people are protected by TPS. They can travel and come back and make the lawful entry if they don't qualify under this new parole. You know, the Karen agreement is still valid. This is the time to do anything that you can possibly do with USCIS or with the immigration courts, because we don't know what's going to happen in November. And once this other person takes power on January 2025, depending if it's Kamala Harris, well, then we can continue with the same policies that Biden started, right? But if it's this other person, Donald Trump, we already know how it's going to play out. So this is the time to do anything. Noble ET, the only thing I know, if it's a humanitarian, for if you've been paroled for humanitarian reasons, if you marry a U.S. citizen, of course you can get adjustment of status because you were really paroled. You don't have a notice to appear, however you were paroled, so you can show them you were paroled for humanitarian reason. So yeah, I think you can adjust status because it's for humanitarian reason that you were paroled. So anybody else? I guess this is it, right? A lot going on. Is it normal? With USCIS, everything is normal. Yeah, it's normal. I mean, you know, you can call them, try to inquire on it. Processing time with USCIS, you know, it's just what it is. Some people are lucky. Lately, they've been making a lot of efforts to process those applications sooner rather than later. But again, yeah, you just reach out to them. Okay, reach out to them. Yeah, this is it, right? So if you have if you need a consultation with me, again, you can schedule it by using the consultation link in the description box below. This is it for today. Until next time, bye bye. Once this rule gets published in the federal register notice for parole in place for U.S. citizen, and and the process for the D 212D3 waiver becomes available, I'll let you know. I'll come back here and I'll make another live session so that we can go through it and start taking applications. Okay? Thank you very much.